And thanks for joining us here on PM Express. Well, if nothing happens, we are going to lose a very important property in London, and that is the offices of the Ghana International Bank. And that is one that we've heard from our High Commissioner in the UK say it is embarrassing to himself, to Ghana, getting a lot of calls from Ghanaians living in the UK. They are embarrassed by what's happening. And why is that? It's because of a certain 140 million Trafigura case. And we risk now our properties in the UK being sold off to defray that particular judgment debt. Let's discuss this. This is a topic we're so familiar with in this country called judgment debt, except now that our properties in the United Kingdom and elsewhere likely going to be subject of sale if we don't find this money to pay. As we know, it's a race against time now to raise the money to get that particular payment.
Hello and welcome back to our channel. Today we delve into a controversial decision that unfolded in Ghana involving the signing and subsequent cancellation of a significant contract, ultimately costing the country millions of dollars, that placed Ghana on the brink of potential asset seizure if the government failed to meet its obligation to the judgment creditor. The events we will be discussing centers around an emergency power purchase agreement, an EPA, signed in 2015 between Ghana and GPGC, a subsidiary of Trafigura.
Really, what happened? It all boils down to the termination of the Trafigura case, the Trafigura deal with Ghana. And
which Ghana, as a tribunal found, had unlawfully terminated prior to the expiry of the contractual term, which arose out of a written agreement for the installation and operations of two power plants. On January 26, 2021, GPGC, a subsidiary of Trafigura, secured a decisive ruling in its favor against the government of Ghana in an arbitration held in the United Kingdom.
Reasons for the termination, but the agreement was also very clear about what would happen if we terminated it wrongly, and GPGC had obviously gone to the London court and argued that that contract was terminated wrongly, as a result of which they got the judgment in their favor. It was in excess of 160 million. We negotiated that particular deal all the way down to 140. We failed to pay, and they've gone now to say, attach the properties that we have in the UK, because
the awarded amount totaling 140 million US dollars, encompassing termination payments, mobilization cost, demobilization, preservation, and maintenance cost. Furthermore, the tribunal imposed cost on the country, covering tribunal expenses and legal fees accrued by GPGC during the arbitration process, inclusive of interest. Now, the decision to cancel the contract prompts questions about the initial decision-making process. Why did the Ghanaian government sign a contract in 2015 only to have it terminated in 2018, being fully aware of the potential legal repercussions that the country will face?
We knew at the time of termination that why GPG's contract was terminated. We knew at the time if we terminated, there was going to be consequences for it.
The then Minister for Power, Boachia Jakon, who wrote to terminate the agreement, and his deputy at the time knew and actually conceded that they have no legal basis to terminate the agreement the way they did. They very well knew that terminating the agreement that way could potentially occasion a financial loss to the state. Yet, they did so willfully, knowing very well what the consequences of their actions were. And this is how much the Akufo-Addo Bawumia government derelicted in its duty to protect the public purse.
Given the substantial repercussions and financial implications at stake, it is imperative to scrutinize the factors that led to the significant fallout and compel the Ghanaian government to once more incur substantial financial liabilities, paying millions of dollars to an investor. Additionally, analysis is warranted to understand the government's lapse in timely filing to contest the arbitration verdict, shedding light on the shortcomings that contributed to this failure. So how did Ghana find itself in this costly situation and what went wrong with the EPA agreement that resulted in its termination. How could Ghana have possibly overlooked the deadline to contest the 140 million judgment against Ghana? Now, let's dive into the background. Between 2013 and 2016, Ghana struggled with a power shortage supply, and in February of 2015, the GPGC initiated negotiations with the Ghanaian government to address the ongoing and pressing power shortage crisis in the country. Desperate to find a solution, as citizens' angers boiled and elections loomed, the Mahama administration signed a raft of power purchasing agreements. The agreement aimed to expedite the relocation of GPGC equipment to Ghana. This move was a strategic response to elevate the impact of ongoing power shortage crisis in Ghana. Now, GPGC, a subsidiary of Trafigura, initially signed an emergency power agreement with the government of Ghana in June 2015 to provide 107 megawatts of power to be completed by mid-2018. This led to the signing of a power agreement in June 2015, which was subsequently ratified by Parliament in July 2015. In November 2016, the transportation of plants to Ghana occurred following an inspection conducted by Francis Zata, the then technical advisor. A year after the initial agreements were signed, the government established a committee to reassess its power purchase agreements, including the one with GPGC. In March 2017, GPGC formally notified the Ministry of Energy about the unavailability of tap-on site and proposed an alternative location. This development coincided with a change in administration in April 2017.
Recently, the new government felt that the agreement was not in the best interest of Ghana,
prompting a comprehensive review of all existing power purchase agreements, PPAs, deemed potentially unnecessary for Ghana's power requirements. The committee's subsequent report focused on the project's perceived emergency nature and the utilization of a 5-year power purchase agreement for an already existing plant with a high tariff, highlighting concerns about potential excess capacity. The estimated total cost of the project over the contract period was reported to be $115.48 million. In August 2017, the Attorney General expressed concerns about the various power purchasing agreements. A committee formed under the directive of the Office of the President explored the possibility of terminating the agreement, estimating a cost of $18 million. In November 2017, the Minister of Energy reported to Parliament that the PPA committee recommended the deferral of 4 PPAs with a combined capacity of 1,810 megawatts until 2018-2025.
According to the Attorney General, that the 4 PPAs with a combined capacity of 181 megawatts should be deferred until 2021. And
additionally, 3 PPAs with a combined capacity of 1,150 megawatts were suggested for deferral beyond 2025, and 11 PPAs with a combined capacity of 2,808 megawatts, including the GPGC Energy Purchase Agreement (EPA), were recommended for termination.
A parliamentary committee was set up and recommended termination. They estimated that it will cost us about 80 million if we terminated. But if we continue with that agreement, we may end up paying for stranded cost or stranded power because the company will generate more electricity than we could consume. And based on the take or pay provisions of the agreement, we will end up paying over $40 million. So based on that calculation, Ghana terminated the agreement.
11 PPAs with a combined capacity of 281 megawatts among the GPGC and with Ghana, and was terminated as a result of that. And they talked about illegality for wanton capacity. They talked about failure to obtain sitting and construction permits. They talked about installation of used plants contrary to policy. They talked about failure on the part of the GPC to fulfill CP's conditions subsequent. All manner of, interventions that were put in there as reasons for the termination, and that the government of Ghana, Attorney General at the time, also advised that the GPGC project will result in cost of, in excess of this, $115 million if implemented with its attendant high tariffs.
Alleging GPGC's failure to fulfill obligations, she suggested were legal grounds for termination.
Dr. Ahenkre's committee suggested that termination could be achieved for some $18 million as opposed to payments of $24.9 million a year for 4 years in excess capacity charges. The basis of that recommendation is not known. The copy of the PPA committee report submitted into the record by Government of Ghana is heavily redacted.
And with an entitlement to an early termination payment. On February 18, 2018, the ministry terminated the deal. President Akufo-Addo's government justified this termination, claiming a savings of nearly $56 million. GPGC, in a protest letter, expressed surprise at the government's actions, considering previous assurances between April and July 2018 that the contract will be reinstated. In 2018, GPGC pursued international arbitration, seeking over $134 million in compensation for what it deemed the unlawful cancellation of its electricity production contract with Ghana. GPGC protested, initiating arbitrations in the United Kingdom, accusing the government of acting in bad faith, claiming financial motivations over technical reasons as alleged by the government. The company highlighted delays in the government's obligations and failure to obtain parliamentary approval for tax exemptions, impacting its cash flow. The company also argued that the termination and repudiation led to substantial losses, highlighting the government's failure to fulfill its obligations. GPGC asserted that the Energy Commission unjustifiably delayed and withheld the issuance of its energy generation license, while the government failed to expedite the approval process as promised.
So the company, of course, went to arbitration. And in this arbitration, Ghana appeared to have taken it a bit more seriously,
seeking over $134 million in compensation for what it deemed the unlawful cancellation of its electricity production contract with Ghana. The government defended its actions, asserting that the agreement never came into effect due to unmet conditions. It argued that the EPA was ineffective, citing breaches by GPGC and the failure to operate within the contractual period. In its counterclaim, the government of Ghana contended that it was owed an early termination payment and sought additional damages due to GPGC's alleged failure to fulfill its part of the agreement. On the 26th of January 2021, United Nations Commission on International Trade Law issued a substantial advance award, finding that the government of Ghana had terminated the EPA between the parties unlawfully and ordering that Ghana pays GPGC compensation.
Nevertheless, Ghana lost the arbitration, and the total cost was about $137 million, which was awarded against Ghana. There were some lapses in the arbitration that a very experienced lawyer or counsel could have dealt with, that could have at least reduced the cost substantially, but that was not done.
Now, slapped with this costly judgment, Ghana expressed its intention to challenge the verdict. However, it failed to do that on time.
So Ghana went to the High Court in England to try and set the award aside. The award was published on 26 January 2021.
Leading to a further delay in challenging the tribunal's verdict. Now, under the British law, the government was afforded a 28-day window to challenge the tribunal's decision. However, Ghana remained dormant until 3 days before the deadline. Seeking an extension, and requested for an unusually lengthy 56-day grace period, double the stipulated duration. The court, however, granted until March 8, 2021 for the government to challenge the decision, only for Ghana to submit its processes on April 1st.
And 3 days prior to the expiration of the 28-day rule under English law, Ghana filed an ex parte application for extension of time. That's 3 days before the 28-day period expired. So on the 22nd February, an extension of time was granted by the court. This was on the deadline, on the last day of the original 28-day. So extension of time was granted on the 8th of March. But the court said that if Ghana were to need any further extension, it should make the application by the 5th of March, not the 8th of March. It should make the application by the 5th of March for that kind of, for any further extension. Ghana did not do that, did not ask for extension, did not file any process for a month. Then it applied in the, I think I've forgotten the exact date, but by the end of March, I think, after almost a month from the 8th of March, Ghana now applied for extension of time. And this application was dismissed.
Ghana's representatives explained the delay by highlighting the recent appointment of the new Attorney General, Godfrey, and COVID-19.
Now, the court said that argument is weak, because if you are asking for extension based on COVID, you have to give particulars. You have to give further and better particulars. It's important because sometimes in our training, in our normal life at home, we take things for granted. So the other side presented information, and it was shown clearly that the Attorney General, who said he was not confirmed, he was, for all intents and purposes, was the Deputy Attorney General, and he has been involved in the case from the beginning. Besides, he was doing other cases in the Ghanaian court. So he was actually acting, he was actually working and representing Ghana. But when it came to the arbitration, he adopted a nonchalant attitude. So the arbitration, the court in England said no, the grounds were not convincing enough for it to grant further extension. So Ghana lost $137 million because of this, and that excludes lawyers' fees. In fact, the domestic law firm they hired in Ghana, they paid them about $1 million.
The delay, characterized as untimely by the UK court, appeared rooted in a convergence of administrative oversights, a misprioritization, and a potential underestimation of the far-reaching consequences of this case. This lapse in filing essential documents within the specified timeframe has left Ghana vulnerable on the global stage. In conclusion, from the initial signing in 2015 to termination in 2018 and subsequent arbitration, critical lapses have surfaced.
But be it as it may, they made various mistakes, including the nomination of the arbitrator. When it comes to nominating arbitrators, it's extremely important who you nominate. Ghana did not take it seriously, and arbitrators were nominated without any serious scrutiny from Ghana. So,
prompting reflections on key facets. A meticulously crafted arbitration agreement is essential to establishing a robust mechanism for safeguarding the contractual rights of governments. The recurring issue of substantial payouts for terminated contracts necessitates a critical examination. How can African governments effectively safeguard funds earmarked for national development?
Now, most of the arbitration issues that affect Africa, or most of the legal disputes that affect us, actually emanate from poor drafting. The problem starts from the drafting stage. So drafting of the legislation, which is very wide and gives so many concessions, drafting of the contracts that it gives the investor such a wide latitude, including the venue for any dispute resolution, even the choice of law. So we see the choice of law or the law that is to govern the contract to say English law, when the investment is actually in Ghana.
The intricacies of navigating business contracts becomes especially formidable, particularly in the realm of international trade and investments. Their relevance is particularly pronounced in industries categorized high-value contracts such as oil, gas, mining, agriculture, and the fishing sector.
The drafting is the key source of much of our problems.
Points to those clauses as a binding legal document, and thereby they can gain 170 million out of the national purse of a bleeding country that doesn't have money to do anything, but we will have to find money to pay people who have done nothing. Who put those clauses in the paper? Who did? Who put those clauses in the paper? Who allowed any abruptly upon the termination of an agreement in a situation where we didn't want a situation where an interministerial committee that had met transcended over two governments, 2016, 2017, come to the conclusion that 11 PPAs can be terminated, that in that termination, the Obroni can still find in his paper the agreement, something that he can punish Ghana with. Who gave that to the Obroni? Why did he give it to him?
If the expenses, as the current government says, surpasses the advantages, what prompted the previous government to endorse the GPGC EPA with Parliament to sign the agreement? Was there a thorough cost-benefit analysis conducted beforehand to assess the viability and implications of this agreement? Ghana now faces a looming prospect of additional judgment debts and arbitrations, not confined to the power sector, but extending to oil, gas, mining, agriculture, and various other industries. How can Ghana strategically fortify its financial position in arbitrations through effective legislations, checks, and balances? Furthermore, what lessons can be drawn from Ghana's failure to safeguard its national interests in this context? And how might other African countries benefit from these insights? What is your perspective on the implications of this case? Now share your thoughts in the comment section below. Thank you for tuning in today, and until next time, stay informed and goodbye.